Alex here with another video on high conflict child custody. In this case, I'm going to cover the best interests of the child. It's something that I've been holding off for a long time because it's a pretty big question and a lot of people don't like the best interests of the child factors because it just ends up coming off as sort of whatever the judge says is the best interest of the child is the best interest of the child, and that's not true. I've seen the Nevada Supreme Court reverse decisions that didn't comply with the actual best interest factors which are listed in our statutes. I'm assuming that all 50 states have either the exact same best interest factors or something somewhat close to what we have here. We have a list of factors. It goes from A to L. My understanding is that A is the most important factor and L is the least important, and they go in order of importance. I believe there's some case law that talks about this, but I'm not absolutely sure. In the actual header of the statute, it doesn't mention that they're in order of importance, but that's something to look at if you're going to actually apply these in your case. These best interest factors are specifically addressed for awarding physical custody, not legal. That's handled separately, and that pretty routinely gets awarded jointly to both parents. Physical custody is really what controls whether somebody can relocate and how complicated the relocation process is going to be if there's a challenge, who ends up paying child support, and how much child support ends up being paid. And then, of course, who the child is primarily living with. So physical custody is really the biggest, most important type of custody, at least in comparison to legal custody. So with that, I'm going to start with the first factor, and this is the wishes of the child. Now, in Nevada, the child has to be of sufficient age. Those are the exact words of the statute. There's no number in there that just magically allows your child to pick which parent they want to live with. And the other part of the statute is that the child has an intelligent preference. So your child can't just say, I want to live with dad just because I said so. And they also can't have like a silly reason that's not in the best interest of the child. So for example, I want to live with mom because she doesn't discipline me as much. Or I want to live with dad because he gives me more gifts. These aren't intelligent preferences that through the lens of the best interest of the child are something that the court can actually consider. So with that, I'm going to go through these factors pretty quickly. If anyone has any questions, and I see a lot of questions on a specific factor, I might do a video just dedicated to that factor. Moving on, the next factor is any nomination of a guardian for the child by a parent. My understanding is that this is something that comes into play when the court is awarding custody to like a relative, and it requires the court to take into consideration the wishes of the parent. So maybe the parent died, or maybe the parent is for some reason unable to care for their children and the court needs to award custody to somebody else. Subsection B is the section that requires the court to consider the wishes of the parents. Subsection C is the parent that's more likely to allow the child to have frequent associations and a continuing relationship with a non-custodial parent. So this factor basically, it's high up there. It's subsection C, and it requires the court to actually look and see, is one of these parents, if I award custody to one of these parents, is that parent going to frustrate the other parent's visitation rights? In my opinion, this doesn't get looked at very seriously. I wish it would. A lot of times there is a background of one parent who's not letting the other parent see the child for whatever reason, bogus reasons sometimes, and sometimes one parent will up and move and just cut off communication, and then the other parent finds them, tracks them down, sues them, and takes them to court. That should be really looked at by any court as, you know, this parent just up and left and vanished. Of course, people have excuses. They'll still come up with stuff. Sometimes it's true, sometimes it's not. Like, they were abusive or dangerous, or they scared me. But I wish the courts would actually look more into this and find out if there's any merit to awarding custody under subsection C, because in my opinion that kind of conduct by one parent, if it's, you know, not backed by some kind of actual threat as to why they needed to run off and hide or cut off contact, that is a bellwether for all kinds of other things that that parent is likely going to do to maybe not necessarily abuse or neglect their kids, but not allow them to grow and you know, develop in probably as healthy and robust manners as maybe the other parent who wasn't trying to keep their kid away from the mom or the dad or whatever's going on in your particular situation. Subsection D, the level of conflict between the parents. This one, you really have to look at it through the lens of best interest of the child. A lot of times people will come to court and say, I can't talk to my ex. We get into fights all the time. We can't agree. There's conflict all over the place. But the level of conflict between the parents has to affect the best interest of the child. And there's actually a case in Nevada. It's Mosley v. Figliuzzi. I like this case because it talks a lot about like the social contract and philosophical issues behind why the courts can't take one parent's accusations of conflict and allow that parent who accuses the other parent of not agreeing to get custody. In other words, this case talks about why the court cannot let one parent say, I can't work with my ex, we can't agree, so you need to give me custody. It tells the judges the problem behind following that kind of logic, and it also talks about how that rewards the parent who is not cooperating by basically incentivizing them to not cooperate on purpose and then complain about it in court and then get primary custody. And that case talks about how the court is supposed to pretty much disregard that, and in some extreme cases even give the other parent, the non-complaining parent, primary custody. And the reason going back to the factor that I was looking at, which is the level of conflict between the parents, is I wanted to explain with an example of how this came to play in my case. So in my case, during the first 2 or 3 years, my ex had complained about the level of conflict non-stop trying to get primary physical custody, and the judge ignored her every time. But then I ended up needing to use that statute to get primary custody, and I succeeded, and this is why. In my case, my son needed to get some surgery. He needed 5 crowns and 2 extractions. Now, the main claim in the motion to modify custody was dental neglect, but a secondary claim was that my ex and I had a level of conflict that was high, so that's subsection D, and that this level of conflict actually was causing our son to suffer. So that's the difference between her saying, we can't agree, we argue all the time, and me saying, we can't agree, we argue all the time, and in this specific way, it hurts the best interest of our son. So there's a difference there. It has to be connected to the best interest of the child. The the next subsection, subsection E, is the ability of the parents to cooperate to meet the needs of the child. Now again, this is pretty much, at least in the sense of the example I just gave you, pretty much the same as subsection D. Arguing that you can't cooperate is not enough. You have to show that the inability to cooperate is affecting your ability to meet the needs of your child. And you have to show that the blame pretty much falls on just one parent, not the other. Because if both parents can't cooperate to meet the needs of the child and both parents are at fault, then you can't really use that factor to award one parent primary custody over the other. Again, same example. In my case, we couldn't cooperate to get our son's dental care, and then I was able to show at an evidentiary hearing that it was entirely her fault, not my fault at all. That's actually in the written order. It's pretty insane. It takes a lot of work to get a judge to come to the conclusion that it's just one person's fault and not the others at all. And because it affected the needs of our son, that factor was taken in consideration in my favor for getting primary physical custody. Again, just reiterating, you can't just go to court and show that you can't cooperate. You have to show that your inability to cooperate is affecting the needs of your child. And again, through the lens of best interest of the child. So subsection F is the mental and physical health of the parents. I didn't use this in my case. I could have worked a lot harder to try to show that there were mental health issues, but I ended up not having to because under the other subsections, I pretty much had enough evidence to win an award of primary physical custody. But I imagine this is pretty obvious. If you can show that your adversary has some kind of mental health issues and that those are going to get in the way of them taking care of their child, then obviously the court has to consider that and award the other parent who doesn't have the mental health issue or the physical health issue primary physical custody. The subsection G is the physical, developmental, and emotional needs of the child. just right off the bat, that makes me think of schooling. There's probably other ways that you can use this subsection, but obviously, and this actually was a minor factor in my case, not taking your child to school is going to affect their physical, developmental, and emotional needs. So I think at the hearing, the evidentiary hearing, I had like one absence and a couple of tardies taking my son to school, and my ex had 14 absences. And so the court did consider that. But because the other issues were more severe, the court didn't really have to look very deeply into subsection G. Subsection H is the nature of the relationship of the child with each parent. I imagine that this could come into play if one parent hasn't seen their child for years and the other parent has been taking care of their child all that time. I don't think you can use subsection H if you like refuse to allow the other parent to see the child, or if you, as I mentioned in a previous example, just up and move and hide and basically not tell the other parent where you went, so that way they can't find you and in effect can't have an opportunity to see their child. I imagine that subsection H comes into place or comes into play when one of the parents is just has every opportunity to foster a relationship with their child, but they just don't for whatever reason, and that's something that the court can take into consideration. Subsection I is the ability of the child to maintain a relationship with any sibling. I haven't seen any case law on subsection I, and I'm not sure how that can really come into play. Perhaps if you have a child who has like half siblings or step siblings and you can show that they have a strong relationship, then the court can put the child with that parent primarily so that they can maintain that relationship with their siblings. But to me, I mean, that can almost be unfair in the sense of, I mean, that's not something that the other parent can control. Hopefully, with joint physical custody being a thing in Nevada, that isn't something that really gets considered often, or hopefully it's something that applies when the court's awarding custody to relatives. So when it's not a dispute between two natural parents. Subsection J is any history of parental abuse or neglect of the child. It's funny that this is a factor listed so low on the totem pole, but it doesn't really matter because there's an entirely separate statute in Nevada that talks about abuse, neglect, and domestic violence is a pretty big thing in Nevada when it comes to awarding physical custody. It's so big that I'm going to do a separate video on it. I'm not going to cover it here. Subsection K is whether either parent is seeking physical custody has engaged in an act of domestic violence against the child or a parent of the child or any other person residing with the child. Again, I mentioned I'm going to do a separate video on domestic violence, so I'm not going to cover subsection K in detail here. And subsection L is whether either parent seeking physical custody has committed an act of abduction. I think this is pretty obvious. In fact, I think there is also another area in the Nevada statutes that says the court cannot give physical custody or even visitation unsupervised to a parent who has abducted a child because obviously you already ordered that parent to allow visitation and that parent has already shown that given a chance they're just going to run. And that's a horrible thing for a child to go through, and that's also a horrible thing for the other parent to go through, to have their child abducted. So again, it's probably something I'll do another video on and cover that that topic more in depth than cover it here. But it is one of the factors, subsection L. So with that, please put some questions down in the comments if you have them, because if I see a lot of questions around one of the factors, that'll be a cue to me to actually do a separate video on just that factor more in depth. With that, I'll see you guys next time.